Hello, I'm Robert. I'm fact-checking to help you if you're scared of many things. And this time, it's people who are scared that because of these stories about the Supreme Court, they seem to have this idea that the Supreme Court is some kind of conspiracy theory to overturn all sorts of things. And there's absolutely there's no basis for that at all. So I'll try and explain a bit. So first of all, it's based on just one justice, Justice Thomas, and he makes lots of. He often is the only justice in the Supreme Court who has the same. He has minority one-person decisions quite often, and it's all based on something he said. So the decision to overturn Roe versus Wade. First of all, they did not decide that abortion is illegal. They said, the Conservative majority said that they don't know, they don't have the expertise or the authority to decide whether abortion should be legal. And then the reasoning they used for that was very complicated, but it's based on something called substantive due process, which is the idea that you have some rights derived from the US Constitution which are not written into the Constitution. And the two bases for it are the historical, or they are based on entrenched right for liberty, which is not explicitly stated in the Constitution. They derive all this from four words. The word due process repeated twice in two different amendments. And that is the entire basis for the idea of entrenched rights to liberty and entrenched rights based on in the history. And so the entire Roe versus Wade decision was based on this substantive due process. They said that the woman does have entrenched rights to liberty, and on her decision about having an abortion, but they said that that many people have said in half the states have said that there also is a question here about entrenched rights for liberty of the fetus, and they say that they don't have the authority or the expertise to decide how these two things connect to each other. And it's not based on privacy, it's based on reliance and on substantive due process, this idea of entrenched rights due to liberty, which are not explicit. There's nothing in the Constitution about abortion, but if someone's pregnant, then do they have entrenched rights? But is there any question there that should be considered about whether the fetus has entrenched rights? And the liberal justice just said, we don't need to think about that, leave that up to the pregnant person. But the Conservative justice says we do have to think about that, but we don't have the authority or expertise to make that decision. And so that's why they overturned Roe, and they said this is something for the legislators and the people to decide. So that's basically what happened with Roe versus Wade. So as you can see, that argument which I've explained in a nutshell, then there's nothing in there that has any relevance to right to contraception, to interracial marriage, to gay marriage, because none of those have this issue of people arguing in different ways based on whether or not a fetus has rights. So it's just not relevant. And Justice Thomas himself agrees. But what Justice Thomas is challenging is he thinks, and now many justices will agree with him on this matter, that the basis for substantive due process is very slender. It's only 4 words. It seems a huge amount to derive out of those 4 words, where there's nothing in the Constitution text to say how they should be interpreted. And based on all that, a lot of the rights that American people have are based on those 4 words. And he's saying, well, is this right? Does the judiciary have the right to establish all these rights for the American people based on just those 4 words and lots of complicated legal reasoning? Isn't that something that perhaps the legislators should be deciding for the American people and legislating certain rights? So that's his reason. He is not doing that because he's conservative. Whether he might be a liberal, he might vote Democrat every single time. There's no way to know. Justices professionally have to keep the two very separate. And so the reason he's doing that is because he's an originalist. And he's looking at the original meaning of the text. What did the framers of the Constitution and the framers of the amendments mean by the words due process? And he sees a very slender basis for the idea that they meant substantive due process in the sense of entrenched rights. So it's like in mathematics. I give an example in my longer videos that some mathematicians think that it's okay to reason using the idea that you can choose one each from many pairs of socks, even there's no way to decide the pairs of socks apart. Whereas all mathematicians agree that you can choose one each from many pairs of boots, because there's a left boot and a right boot. And you can, even if you alternate and it's left and right alternately, or whether it's always the left or always the right, there's always ways of choosing between them. But if there's no distinction between the two as in socks, then can you choose one of each? And you get some very strange mathematical conclusions if you say that you can choose one of each when you can't tell them apart. And so in the same way, the justices, he's basing it on a similar kind of logical reasoning based on premises like that. If you could think, he's got some ideas, some things that he has as premises, and the other justices, the liberal justices, they don't have the same premise. So some mathematicians have the axiom of choice, some don't. In the same way, some have look at both types of systems and how you compare the two with each other and compare and contrast them with each other. And some say, well, we just do all the maths and we say, well, these results come from choice and these results don't, and then leave it at that. So it's a very similar situation with law, that some of the justices are originalists and some think you should look at how the words are understood today rather than how they're understood by the original framers, and lots of different ideas. And even the originalists, some of them say we should look at how the framers thought about the ideas while they were working out the law, and some say no, you don't look at what the framers think at all, you just look at how the ordinary people understood the law after it was passed. So those are two of several branches of originalism, and based on which branch of originalism you belong to in your interpretive legal philosophy, and some people will use bits of each, and you're not necessarily always one or always the other, then you'll come up with different legal decisions. Just like if you're a mathematician, you use choice or you don't, you come up with different mathematical theorems. So it's that's how the justices think about it, don't they? So, as an example, one of the things people worry about is, suppose that they did overturn substantive due process, then wouldn't that overturn the right to interracial marriage? Well, Justice Thomas is in an interracial marriage. That's his wife there. So if that question ever came up to the Supreme Court, well, he would have to recuse himself because he's too personally involved in the question. And so it would be an 8-0 decision instead of a 1-8. Instead of 1-8, be 0-8, because he wouldn't be there. He wouldn't be permitted to decide on that. At least I don't think he would. There's quite clear criteria on when you accuse yourself as a justice. But I would have thought that being in an interracial marriage himself would mean that he couldn't possibly make a decision on the legality of interracial marriages. But suppose he did, and he was a very dedicated originalist, it's possible he decided his own marriage is illegal. That's how much of a separation there is between if it ever came to the courts, but he would be in a minority of 1 to 8, and the others would decide against. So, but he'd recuse himself because he couldn't be involved. But that gives an idea of how justices think. So I hope you can see from this, there's really no risk of any of these things being overturned, at least not based on this idea of substantive due process, which is what Justice Thomas thinks needs to be looked at again. Because there's nobody else in the Supreme Court is shown any interest in taking up just substantive due process. So that's basically this in a nutshell, a very short explanation of why you don't need to worry about this. I go into loads and loads of detail, and also in my longer videos I explain that 5 of the justices are Catholic. The 6 Catholics, it's much more than the average in the United States on the Supreme Court, and 5 of those decide to overturn Roe. This does not mean that those 5 were all pro-life. More than half the Catholics in the United States are pro-choice. That doesn't mean that they have personal decisions, but more than half of Catholics think that the law should permit other women to make the choice, even though they themselves presumably would be very unlikely to choose an abortion because of Catholic views about life, the sanctity of life. But so it's well possible that half of those justices on the Supreme Court who decide to overturn Roe are actually pro-choice, and that would actually, if you came to the midterms, then Biden's made it very clear he'll do a carve-out for abortion and for other things connected with privacy, even though this is nothing to do with privacy. But I don't think Biden, he's not a lawyer, he's not a justice, I don't think he knows that. But or they don't think they have a very much vaguer, imprecise, not the kind of mathematically precise way of thinking about these things. I'm not sure if he quite gotten on that this decision was nothing to do with privacy. Both the Supreme Court and Casey agreed that it's nothing to do with privacy. But he's going to do a carve-out for abortion and other things like gay rights and so on that he thinks in his informal way are to do with privacy. And he's also going to do a carve-out for voters' rights. So now, if in the midterms, it's well possible that some of those Supreme Court justices who decide to overturn Roe go to the ballot box and they vote for someone for the Democrats in the personal hope, from their own personal views, that they want to Roe codified into law. That's entirely possible. There's nothing to prevent that. And it's indeed, I think it's quite likely, because they were chosen by the legal interpretive philosophy, and that there's no reason really for that to correlate to their personal views on choice, pro-choice or pro-life as Catholics. And then also if you look at and one of the Catholics on the Supreme Court voted not to overturn Roe. Then if you look at what Catholic countries like Brazil and Mexico and so on choose, then several of those, then only recently, last year, that any of them actually, Mexico, Brazil is still illegal. You can still get a 2-year plus a multi-year prison sentence for getting an abortion if you're a pregnant person in Brazil. And yet all of them made gay marriage legal several years ago, and 2 of them, through the judicial proceedings, decided that gay marriage should be legal. But they still have, until last year, several of them, that abortion was illegal. And there's Brazil, it's still illegal, it's still criminal. It's still a multi-year sentence if a woman is found to have caused an abortion on herself or got an abortion from someone else. So, or a pregnant person more generally. So, like a pregnant trans or whatever. So, I hope that helps you understand. That's it. Those are the main points. I'll now upload this, and it's a little bit shorter.